She had 180 seconds to avoid jail. What Judge Ketanji Brown Jackson didn't know was that she had just threatened the wrong Congress member. Congressmember Mamdani, I am holding you in contempt. You have 3 minutes to explain why I shouldn't order the marshal to take you into custody right now. The courtroom froze. The most respected federal judge in Washington had just threatened to jail a sitting member of Congress. But then nobody expected what happened next. Not the prosecutors, not the defense, and certainly not Judge Jackson. Your Honor, before you exercise that power, you should know that the Supreme Court has specifically ruled in 3 separate cases that what you're attempting to do is unconstitutional. In the next 90 seconds, Congressmember Zohran Mamdani didn't just avoid jail. He completely flipped the script on one of America's most respected judges. And by the end of the hearing, that same judge who wanted him behind bars was practically asking for his legal advice. This isn't just another courthouse drama. This is the story of what happens when unshakable knowledge meets unchecked power, and why everyone who values justice needs to witness what happened next. Like and subscribe now to see how this legal genius turned a jail threat into one of the most extraordinary courtroom victories in recent history. The full story will leave you speechless. Judge Ketanji Brown Jackson had built her reputation on being one of the most respected federal judges in Washington, D.C. Appointed to the U.S. District Court for the District of Columbia in 2013, she had previously served as an appellate judge and clerked for the U.S. Supreme Court. Her background as a former federal public defender and advocate for criminal justice reform gave her a deep understanding of fairness in the law, making her one of the most highly regarded jurists of her generation. At 53, Judge Jackson carried herself with the poise and confidence that came from decades of legal experience. Her hair was perfectly styled, her black robe impeccably pressed. Known for her incisive questions and commitment to justice, she commanded respect and often left those in her courtroom with a sense of awe. The judge had overseen numerous high-profile cases during her tenure, including high-stakes criminal and civil rights trials. Legal analysts often described her as fair, meticulous, and keen on balancing both sides of the law. Attorneys respected her for her professionalism and approachability, though they understood her dedication to upholding the law and its implications. In recent years, Judge Jackson had become increasingly protective of the court's dignity, growing frustrated with any actions that could potentially undermine the justice system's integrity. She had reprimanded several attorneys for overstepping legal bounds, and her contempt powers were not used lightly. Congressmember Zohran Mamdani represented a different kind of legal authority. At 31, the freshman representative from New York had already built an impressive career before entering Congress in 2021. What wasn't widely known outside political circles was that before running for office, Mamdani had specialized in human rights law, with a focus on protecting marginalized communities from systemic abuse. After graduating with honors from Harvard Law School, Mamdani had spent years defending vulnerable populations and pushing back against systemic injustice. His legislative career had quickly made him a rising star in the field of legal reform, particularly with his fierce advocacy for racial justice and civil liberties. He had successfully argued before the New York State Supreme Court and had won several landmark cases involving judicial misconduct. He had also authored a respected law review article titled Constitutional Guardrails: The Proper and Improper Use of Judicial Contempt Powers. Zohran Mamdani had come to observe the proceedings in Judge Ketanji Brown Jackson's courtroom because of a controversial case involving First Amendment protections for political speech. The case had implications for legislation he was working on in Congress. His presence was not as legal counsel, but as an observer with a particular interest in the constitutional questions being debated the day before. Following a controversial ruling that limited key defense evidence, Mamdani had been approached by reporters outside the courthouse. His comments had been measured but pointed. While I respect the court's authority, today's ruling appears to disregard established precedent on protected political speech. The selective application of First Amendment standards raises serious questions about the decision-making process in these proceedings. Those carefully chosen words spoken by a sitting member of Congress with significant legal credentials had apparently infuriated Judge Jackson, leading to the confrontation now unfolding in her courtroom. Have you ever witnessed someone stand their ground when facing an authority figure who overstepped their bounds? Share your experiences in the comments below. We'd love to hear how you handled similar situations. The tension in Courtroom 22 was palpable as proceedings began that Friday morning. The grand wood-paneled room with its high ceiling and imposing bench seemed designed to remind everyone of the judge's authority. Sunlight streamed through tall windows, illuminating dust particles floating in the air and casting dramatic shadows across the marble floor. Judge Jackson entered precisely at 9:00 a.m., her expression stern as she surveyed the packed gallery. Reporters filled the front row, notebooks ready. Legal observers, law students, and curious members of the public occupied every available seat. Court security officers stood at attention, sensing the unusual tension in the air. Before we proceed with today's scheduled matters, Judge Jackson began, her voice carrying that distinctive tone of judicial authority, there is a preliminary issue I need to address. She fixed her gaze directly on Congressmember Mamdani, who sat in the second row of the gallery. Representative Mamdani, please approach the podium. A ripple of whispers spread through the courtroom as Mamdani, dressed in a tailored navy suit with a single strand of pearls, rose calmly and walked to the center of the courtroom. Unlike others who typically appeared nervous when singled out by Judge Jackson, Mamdani's demeanor remained composed and professional. Congressmember Mamdani, Judge Jackson continued, I have been made aware of statements you made to the press yesterday regarding my ruling in the United States versus Marson case. Your comments suggested that this court has applied First Amendment standards selectively and questioned the integrity of the decision-making process in this court. The judge's voice hardened. Such statements, particularly from an attorney and member of Congress, risk undermining public confidence in these proceedings and could constitute contempt of court. I am considering sanctions, including possible detention, until a formal apology is issued. The courtroom fell completely silent. The court reporter's fingers moved rapidly across her stenotype machine, capturing every word of what was quickly becoming an extraordinary confrontation. Before I make that determination, Judge Ketanji Brown Jackson continued, You have 5 minutes to explain why I should not hold you in contempt. Mamdani nodded once, opened his leather portfolio, and began a response that would completely transform the dynamics of power in that courtroom. Thank you, Your Honor, he began, his voice clear and respectful, yet unwavering. Before addressing the specific allegations, I'd like to clarify my capacity here today and the legal standards that govern this situation. Judge Jackson leaned forward slightly. Congressmember Mamdani, I'm well aware of who you are. What concerns me is your commentary undermining this court's authority. I understand, Your Honor, Mamdani replied, and that goes directly to my first point. I am not appearing before you as counsel in this case. I am here in two distinct capacities. As a member of Congress with constitutional oversight responsibilities regarding our judicial system, and as a licensed attorney with specific expertise in the constitutional limitations on contempt powers. Mamdani reached into his portfolio and removed a document. With the court's permission, I've prepared a brief memorandum addressing the legal standards for contempt in this precise context. After a moment's hesitation, Judge Jackson nodded. You may approach. As the judge reviewed the document, Mamdani continued, Your Honor, the Supreme Court has established clear guidelines for when commentary on judicial proceedings crosses into contemptible territory. In Bridges versus California, the court held that such sanctions are appropriate only when comments pose a clear and present danger to the administration of justice. Judge Jackson looked up, her expression still stern, but with a hint of caution now. I'm familiar with the case law, Congressman member. Your statements question this court's impartiality and application of constitutional standards. With respect, Your Honor, Mamdani responded, my actual statement was that the selective application of First Amendment standards raises serious questions about the decision-making process. That's a substantive legal observation about inconsistent application of constitutional principles, not an attack on the court's integrity. He removed another document from his portfolio. I've included the full transcript of my remarks to the press. You'll note that I preface those comments by expressing respect for the court's authority. As Judge Jackson reviewed this second document, the atmosphere in the courtroom subtly shifted. Several legal observers exchanged glances, recognizing that Mamdani was mounting a sophisticated defense rarely seen in contempt proceedings. Even if I accept your characterization, Judge Jackson said, her tone slightly less certain. Public statements that question a court's application of constitutional standards can still interfere with proceedings by influencing public opinion. Mamdani nodded respectfully. That brings me to my third exhibit, Your Honor. In Landmark Communications versus Virginia, the Supreme Court specifically addressed the constitutional protection for commentary on judicial proceedings, particularly by public officials with oversight responsibilities. He presented a third document, which Judge Jackson accepted with a slight frown. Furthermore, Mamdani continued, in Standing Committee versus Yagman, the Ninth Circuit held that an attorney's criticism of a judge is protected speech unless it was both objectively and subjectively a false statement of fact. My comments were neither false nor presented as factual assertions about your motives. They were legal observations about the consistency of rulings with established precedent. The courtroom remained absolutely silent as Judge Jackson reviewed the materials. Even the prosecutors seated at their table to the left appeared to be reassessing the situation. Mamdani wasn't finished. Your Honor, he began, I've included as my fourth exhibit my own legal credentials and expertise in this specific area of law. I've successfully litigated 3 cases before the New York Commission on Judicial Conduct involving the limits of contempt power and authored a law review article on this precise constitutional question. This revelation caused several journalists to frantically scribble notes. Judge Jackson's expression had now visibly changed from stern confidence to cautious reconsideration. And finally, Your Honor, Mamdani said, I've included as my fifth exhibit the transcript from United States v. Rodriguez, a 2019 case in which you yourself noted, and I quote, thoughtful criticism of judicial decisions, even strong criticism, serves an important function in our legal system and rarely rises to the level of contempt, absent direct interference with court operations. A faint murmur rippled through the gallery before being silenced by a sharp look from a court security officer. Judge Jackson stared at the document, clearly surprised by Mamdani's knowledge of her own prior rulings. Your Honor, Mamdani said, his voice still respectful, but now carrying a quiet authority that commanded the room's attention. I stand by my comments as legally accurate, constitutionally protected, and consistent with my responsibilities, both as an attorney and as a member of Congress. They were measured observations about constitutional application, precisely the kind of good faith legal commentary that you yourself have recognized as legitimate in previous cases. He closed his portfolio and stood straight, looking directly at the judge. Unless the court finds that my comments posed a clear and present danger to these proceedings, a standard that requires specific evidence of harm rather than general concerns about propriety, the Constitution and this court's own precedent do not support a finding of contempt. The silence that followed was profound. Judge Jackson stared at the documents before her, then at Mamdani, clearly recalibrating her approach. What had begun as a routine exercise of judicial authority had transformed into something far more complex. After a long moment, Judge Jackson spoke. I'll need time to review these materials more thoroughly. This court will take a 15-minute recess. With that, she rose and exited to her chambers, leaving the courtroom buzzing with whispered conversations about what had just transpired. The 15-minute recess stretched to 30 minutes as Judge Jackson remained in her chambers. When she finally returned, the courtroom immediately fell silent again. The judge's demeanor had noticeably changed, her earlier certainty replaced by a more measured approach. She adjusted her glasses and looked directly at Mamdani, who had remained standing at the podium during the recess, his posture perfect, his expression serene. Congressmember Mamdani, Judge Jackson began, her tone markedly more collegial. I have reviewed the materials you provided, as well as the full transcript of your statements to the press. Before ruling on this matter, I want to acknowledge several points. She glanced down at her notes. First, I recognize that your comments were more nuanced than initially characterized. You did indeed preface your remarks with an expression of respect for this court's authority. Mamdani nodded slightly but remained silent, allowing the judge to continue her reassessment without interruption. Second, your legal analysis regarding the constitutional standards for contempt is comprehensive and well-supported. The cases you've cited establish a high threshold for sanctioning commentary on judicial proceedings, particularly from public officials with oversight responsibilities. The judge paused, seeming to carefully consider her next words. Third, I must acknowledge that your expertise in this specific area of law is substantial and directly relevant to the question before us today. A murmur of surprise rippled through the courtroom. It was unusual for a judge, particularly one with Judge Jackson's reputation, to publicly acknowledge being educated on the law by someone appearing before them. In light of these considerations, Judge Jackson continued, I am withdrawing the contempt warning. Your comments, while critical of certain rulings, did not cross the constitutional threshold for sanctions as established by the Supreme Court. The gallery remained silent, but the shift in energy was palpable. What had begun as a power dynamic, wholly in the judge's favor, had transformed into something approaching a dialogue between legal equals. But Judge Jackson wasn't finished. What she said next surprised everyone in the courtroom. Congressmember Mamdani, while this concludes the contempt matter, your submissions have raised important questions about the First Amendment analysis in yesterday's ruling in the Marson case. She looked toward the prosecutors and defense attorneys. Would counsel have any objection to Congressmember Mamdani submitting an amicus brief addressing the constitutional standards for protected political speech as they relate to this case? The defense attorney immediately stood. No objection, Your Honor. We would welcome such a submission. The lead prosecutor hesitated, clearly caught off guard by this unexpected development. After a moment, he rose as well. The government has no objection to an amicus brief, Your Honor, provided we have an opportunity to respond to any arguments raised. Of course, the judge nodded. Standard procedure for amicus submissions. She turned back to Mamdani. Congressmember, would you be willing to provide the court with your analysis? I want to emphasize that this is entirely voluntary and separate from the now resolved contempt matter. Mamdani's composed expression gave way to a brief smile, not triumphant, but reflecting genuine appreciation for the judge's professionalism in reassessing her position. I would be honored to assist the court, Your Honor. I could provide a brief addressing the specific constitutional questions regarding the protection of political speech by the end of next week. Judge Jackson nodded. The court would appreciate that. She checked her calendar. Let us schedule a hearing to consider the amicus brief and any responses for 3 weeks from today. As Mamdani gathered his materials, something truly extraordinary happened. Judge Jackson removed her glasses and addressed the packed courtroom. Before we proceed with today's scheduled matters, I want to make an additional statement for the record. The courtroom, already attentive, seemed to hold its collective breath. The proper functioning of our justice system depends on each participant recognizing their role and its limitations. This includes the bench. She paused, choosing her words carefully. The contempt power is perhaps the most significant authority granted to a judge, as it allows the judge to act as both accuser and adjudicator. That is precisely why it must be exercised with the utmost restraint and strict adherence to constitutional boundaries. Legal observers in the gallery exchanged surprised glances. Such candid reflection from the bench was rare, particularly from a judge of Jackson's stature. I want to thank Congressmember Mamdani, not only for his legal expertise, but for the professional manner in which he presented it. This exchange serves as a reminder that our legal system functions best when all participants approach their roles with both knowledge and humility. Judge Jackson then made a final statement that elevated the already remarkable exchange into something truly historic. Furthermore, in light of the constitutional authorities provided by the Congressmember, I am directing my clerk to schedule a reconsideration hearing regarding yesterday's evidentiary ruling in the Marson case. This court has a duty to ensure that its decisions are consistent with both precedent and constitutional requirements. With those words, Judge Jackson had done something vanishingly rare in judicial proceedings, publicly acknowledged a potential error, and committed to reconsidering it in light of sophisticated legal arguments she hadn't initially contemplated. As proceedings moved to the day's scheduled matters, Congressmember Mamdani quietly exited the courtroom. Outside, a crowd of reporters waited, but he offered only a brief statement. Today's proceedings demonstrate the strength of our constitutional system when all participants approach their responsibilities with seriousness and mutual respect. By noon, legal reporters who had witnessed the proceedings filed stories with headlines that captured the dramatic reversal. Washington Post, From Contempt to Collaboration. How Congressmember Mamdani Transformed a Judicial Confrontation. New York Times, in rare reversal, federal judge withdraws contempt, threat after constitutional lesson. Legal Times, constitutional expert in Congress, Representative Mamdani schools, federal judge on contempt limits. Within hours, law professors and legal commentators were already analyzing the exchange as a textbook example of effective constitutional advocacy. The ripple effects of the extraordinary courtroom exchange between Judge Jackson and Congressmember Mamdani extended far beyond that Friday morning in the D.C. federal courthouse. By Monday, video clips of the proceeding released through the court's official channel had gone viral in legal circles. Law schools across the country requested permission to use the footage in courses on constitutional law and professional responsibility. Harvard law professor Miranda Chen told reporters, "What makes this exchange so remarkable isn't just the legal substance, though that was impeccable. It's the procedural mastery and professional tone." Congressmember Mamdani didn't grandstand or make it personal. He systematically dismantled the legal basis for the contempt threat while maintaining absolute respect for the court as an institution. We'll be teaching this approach for years to come. The public reaction extended beyond legal circles. Social media filled with comments reflecting admiration for how Mamdani had handled the situation. No shouting, no drama, no playing victim, just pure legal brilliance and unshakable composure. This is what real power looks like. #legal masterclass. Notice how he never attacked the judge personally, even while firmly challenging her legal reasoning. That's professionalism at its finest. #respectful advocacy. Organizations focused on judicial accountability praised the exchange as a model for how legitimate criticism of judicial proceedings could be presented effectively. The Constitutional Accountability Center issued a statement noting that Congressmember Mamdani demonstrated how robust, principled critique of judicial decisions can strengthen rather than undermine our legal system when presented with appropriate expertise and respect. Perhaps most significantly, the Federal Judicial Center, the research and education agency of the federal court system, announced it would develop new training materials for federal judges on the constitutional limits of contempt power, directly citing the Jackson-Mamdani exchange as a catalyst. 3 weeks later, as scheduled, Judge Jackson convened a hearing to consider Mamdani's amicus brief on First Amendment protections for political speech. The Congressmember had submitted a comprehensive 40-page analysis that legal reviewers described as exceptionally thorough and a model of constitutional analysis. The courtroom was even more crowded than before, with law professors and constitutional scholars joining the typical observers. Judge Jackson opened the proceedings with remarkable candor after reviewing the amicus briefs submitted by Congressmember Mamdani, along with the responses from both parties. This court has reconsidered its previous ruling regarding the admissibility of evidence in the Marson case, she continued. The constitutional analysis provided in the amicus brief correctly identifies a line of Supreme Court precedents that this court had not fully considered in its initial ruling. These authorities establish that when evidence touches on core political speech, courts must apply a more rigorous standard than the one this court initially employed. The judge then did something that sent another ripple of surprise through the courtroom. She directly quoted from Mamdani's brief. As Congressmember Mamdani aptly noted in his submission, when First Amendment interests intersect with criminal proceedings, courts must ensure that evidentiary standards do not create a chilling effect on protected political expression, even when investigating potential violations of other laws. After a thorough review of the specific evidence at issue, Judge Jackson reversed her earlier ruling, allowing the defense to present materials that had previously been excluded. The impact on the case would be substantial, potentially changing its entire trajectory. Following the hearing, Congressmember Mamdani spoke briefly with reporters gathered outside the courthouse. True to his consistent approach, he focused on principles rather than personalities. Today's ruling demonstrates something important about our legal system, he said. When judges and advocates focus on constitutional principles rather than pride or position, justice is served. When judges and advocates focus on constitutional principles rather than pride or position, justice is served. Judge Jackson's willingness to reconsider her ruling based on legal authority reflects the highest traditions of the judiciary. When asked if he felt vindicated after initially facing a contempt threat, Mamdani smiled slightly. "This was never about vindication for me personally. It was about ensuring that constitutional standards are properly applied in a case with significant implications for political speech. The real vindication today is for those constitutional principles." The long-term impacts extended far beyond a single case. In the months that followed, several notable developments occurred. The Judicial Conference of the United States commissioned a special committee to review guidelines for contempt proceedings with particular attention to commentary on judicial proceedings by public officials and legal experts. Law schools across the country incorporated transcripts from both hearings into their curriculum on professional responsibility and constitutional law, often paired with Mamdani's Amicus brief as a model of effective legal writing. Judge Jackson herself began speaking at judicial conferences about the importance of openness to reconsideration, using her own experience as a case study in judicial humility and the ongoing learning required of those on the bench. Perhaps most significantly, a subtle shift occurred in how federal judges approach criticism of their rulings. Several judges explicitly cited the Jackson-Mamdani exchange when declining to pursue contempt sanctions for public commentary, instead inviting more substantive legal engagement with their decisions. 6 months later, at a conference on judicial ethics at Columbia Law School, Judge Jackson and Congress member Mamdani appeared together on a panel discussing the boundaries of contempt power and legitimate criticism of judicial proceedings. Their respectful, collaborative dialogue served as a powerful demonstration of how initial conflict could evolve into constructive engagement when approached with professionalism and commitment to legal principles. During the question and answer session, a law student asked what lesson they should take from the now famous exchange. Judge Jackson responded first. "Remember that the goal of our legal system isn't winning arguments or asserting authority. It's arriving at just outcomes through faithful application of constitutional principles. Sometimes that requires reconsidering your initial position, and there's no shame in that, only integrity." Mamdani nodded in agreement. "And remember that effective advocacy doesn't require theatrics or personal attacks. When you're grounded in solid legal authority and present it with clarity and respect, you create space for genuine reconsideration rather than defensive resistance." The moderator noted that their exchange had already become a case study in how our adversarial legal system functions at its best, not as a zero-sum competition, but as a collaborative search for constitutional truth. As Mamdani left the stage, he was approached by a group of young law students eager to speak with him. One asked how he had maintained such composure when facing a contempt threat from one of the most powerful federal judges in Washington. He smiled and said something that would be quoted in law school classrooms for years to come. "When you know the law is on your side, you don't need to raise your voice. The Constitution speaks loudly enough on its own." If you found value in this story of how preparation, expertise, and principled advocacy can transform even the most challenging legal confrontations, please like and subscribe to our channel. We're committed to bringing you authentic moments that reveal how our legal and political systems function at their best. What other examples have you witnessed where expertise and composure prevailed over intimidation? Share in the comments below and join our community dedicated to celebrating truth, accountability, and excellence in public discourse.